You don't
we
remember what day? We're live, by the way. You don't
Yeah,
remember what day it was? That's not a good start.
I think it was Friday. I'm not sure.
All right. Okay. These people, all these thousands of people here who
The
are,
billion.
I think it's 1,000,002
Is
at
it a
this point
million
in
too?
time. 1,000,002. That's my counter. It says, and Elon Musk is watching. How do you like
Is he?
that?
Nice.
I thought, because of the topics of, what's been going on the past week, and I determined that Finra stinks. Really, that's my determination. So in honor of that tonight, I'm going to start off the live stream with a little cologne. Just get rid of the stink a little bit.
Is that 100 miles per hour?
That's this is I don't know if I can even say it. Am I going to get a sponsorship for this? Sponsored by.
No, that's 100 miles per hour. Did you know he's got a cologne named after him?
I did not know that. It's very important.
Yeah,
Obviously, not legal advice and little tiny JR here tonight. We're going to be talking about stuff that's relevant, that maybe occurred in the past week that everybody's heard about, plus other stuff. And please like, subscribe, and do something. Really,
hit
please.
that like button, folks. Hit that like button.
Hit the like button, hit the subscribe button, hit
Doesn't
any
do
button.
me any good.
And make sure your animals are watching this too, please. Because the animals, I've determined that cats like JR and dogs like not legal advice. Just to let you know. And I like talking in the third person too. It's a lot of fun. Last week we talked at the end, we were going to talk about robots. So tonight, surprisingly, tonight's entire live stream is going to be on robots. Oh, maybe not. Maybe we won't. We have two competing jokes tonight, by the way.
Just
one
two.
Was offered by our friend William Friend. He sent it to me directly, and we're going to compare the two. I'll let all the followers, all the 1.5 billion followers, decide which one they like better. William Friend's is, how do shellfish go to the hospital? In a clambulance.
These are so stupid.
All right, and mine, the competing one. What is a frog's favorite kind of shoe? An open-toed sandal.
Oh my God.
All right.
Hey, Rich, how are you, man?
I'm good. Looking forward to this one, actually. And just a quick reminder.
I was talking to Don, man.
Will Stewart is going to be on Tuesday night. Just a reminder, 7:30 Eastern, same setup. So obviously I wanted to start talking about MMTLP because of the wild week that we had. And, we did a quick one on the Wells notice and just kind of recap your view on the Wells notice.
Well, the Wells notice is the end of the SEC investigation. It gives the parties that are subject to the notice 30 days to respond. We don't know if those responses will be made public. We do know that George Pelicaris as well as John Berta were both subject to the Wells notice, as well as Meta Materials was subject to the Wells notice. Was received on July 20, and it was 4 varying statutes that dealt with misrepresentation, market manipulation, but it all went back to the merger. They weren't specifically focusing on MMTLP. They were focusing on the merger and the assets. So, you and I both talked, the truth is always a defense to any type of investigation, whether that's civil or criminal. The truth is a defense. So we'll see. The facts, it's an opportunity for the facts to come to light. Whether we like those facts or not is an entirely different story, but it's an opportunity for the facts to come to light.
And I should have mentioned, we're 2 lawyers, but don't trust anything we say. We don't know much of anything, so take it at that.
We're not necessarily 2 lawyers, not necessarily.
Yeah, we're not necessarily 2 lawyers either. Yeah, I found it interesting, the timing. Obviously, we discussed it, the timing of the Wells notice, and I kind of I did a video. I did 2 videos, one on Saturday, one on Friday. On Friday, I did a video, and basically my premise was, I believe the SEC's after Finra, and I'll kind of go back to the Wells notice.
Right.
And that was before the letter from Congress went forward. So there was a letter on Friday from 15 Congress people to Gary Gensler, the SEC, requesting that they check into the MMTLP. I'm doing broad language, checking into the MMTLP situation and prepare some type of response. And that was due, I think, August 11th, whatever format that is in. So that occurred after. So my premise was, I was looking at the Wells notice and I was thinking back a couple of months ago. And, obviously you and I have talked, so I've had some information at times that has turned out to be, I think, accurate. The timing may not have been exactly as I had hoped, but basically a lot of the information tends to be accurate. I didn't know for certain. At the time I wouldn't know for certain, but it seemed like it's been accurate. So one of those pieces of information I got a couple months ago was that the SEC was pissed at Finra. I mean, really pissed. And as to their handling of MMTLP, and because they recognized there was a problem, and they obviously wanted a solution. So when I saw that Wells notice, it made me think about that, because the Wells notice requested, it asks the three targets. So I use the term target in quotation marks, because just because they've received a Wells notice doesn't mean diddly. Doesn't mean they're liable, responsible. Doesn't mean there's going to be a actual legal action, but it does mean that they have the opportunity to respond to the contents of the Wells notice. Now, we don't have the Wells notice. All we have is the filing that references the Wells notice. But what's going to happen, I presume, at some point in time, the three named parties, which would have been John Berta, George Palikaris, and MMAT, they could do it, I guess, collectively. So they could do it as all one filing, or they could do it individually. But they'll have an opportunity kind of to explain why things happened as they did. And they can do it as in much detail as they want. And they can provide as much documentary proof as they want. So in my mind, that is an invitation from the SEC to please slam us. And in this case, when I mean slam us, I think the SEC, even though they have supervisory obligations over Finra, they've already indicated they're pissed, at least off the record. They've indicated they're pissed. The fact that they put out the Wells notice to me suggested they were hanging Finra out to dry, and because Finra would be exposed in the response to the Wells notice. And I mean, it made me more clear on that point after the letter to Congress, because that made me believe that Gensler would have known about the letter coming, just because they're in the government, either out of courtesy, they would tell him that the letter is coming, or some staffer would speak to some other staffer and it would come out. We wouldn't know, but they would know. And they would have known that before they elected to put out the Wells notice. And if they put out, I'm sorry, you go ahead for a while.
I was just going to say, I agree that Gensler knew the letter was coming. I just, that's how politics work. And whether or not they gave him a courtesy heads up, I tend to think you're right. It was the staffers. I mean, the staffers are the ones that do all the work. The letter was drafted. It probably made its rounds through the people that had agreed to sign it. Everybody gave their input. It went through round 2, round 3. I mean, that letter was probably a week to 2 weeks in the work before the final version was done. I suspect some staffer talked to some staffer at the SEC and said, hey, you're getting this letter, just so you know. They might have even sent them a draft or might have sent them a heads up before it was made public. But yeah, you're right about that. Go ahead.
No, go ahead and finish. I'm sorry.
Well, as far as the Wells notice and the speculation around that, and again, it's all speculation. We do not know. I was indifferent at first. I mean, when I looked at the statutes, I thought, like you did, that if they want to pin this on Finra and wipe their hands of it, which is more or less what I think they're doing, you start at the beginning. The only place to start is through a Wells notice that gets targeted to the companies, and you give the subjects the opportunity to respond. And you know, I was 50-50 on that when we first read the Wells notice, and then the next day the S1 came out, and now you're like, man, this is getting a little crazy. And then the day after that, the congressional letter came out. Now you have to sit back and wonder, like, well, you had the S1, then you had Finra release their communications, which that's unheard of. I mean, that just is mind-boggling that they released those communications out. And it really makes you wonder, why did they make that public? What was it about the S1? Or it might be that Finra also had a courtesy heads up that the SEC was getting that congressional letter and tried to get out in front of it. But you have to wonder what the people at Finra were thinking that made them think that releasing those communications was a good idea. I mean, I'm just blown away that they would release that, knowing full well the community was going to read it and dissect it and you know, motivate the community again.
Yeah. Well, the reason why I believe that SEC is targeting Finra directly, and so, you know, I'm telling Finra in this video or live stream we're doing now, you don't have an ally in the SEC. And the reason why I'm saying that again, I don't see there any way that Gensler didn't know that this letter is coming from Congress. If he knows, and they're asking him, basically, they're asking him very pointed questions, and they're directing, you know, not in a political way, political language. They're saying, "What's up? You know, we have problems. Explain yourself." I don't see, in light of that, unless they were going to pin it on somebody else, giving the three targets an opportunity to basically target those guys. Right. So Congress is going after these guys. Then they send out the Wells notice to target them again. No, I don't believe that. I believe that the SEC knows that FINRA's dirty here and knows that FINRA's on the spot and is hanging them out to dry. Because the bottom line is, and this is from the start, we're not making up the facts. Nobody is like saying, this is not like a gray area where some people got what they were entitled to. This is a slam dunk that this was screwed up.
Right.
So I don't see the SEC exposing themselves, but I see the SEC exposing FINRA and putting the heat on them. And the only heat the SEC would take in that regard was they have supervision over FINRA. Okay. So they'll make some excuse. This is my view. And again, pure speculation, but they'll make some excuse. Yeah, you know, unfortunately, we don't have enough staff, enough money to watch everything. We rely on FINRA to do that. That's why they're there. You know, we'll do better in the future about supervising whoever, but those guys are the ones you have to speak to. That's what I think the message is. And, you know, getting to what you were saying about their response to the next bridge, you know, I'm going to call it the dividend. Let's just, for our purposes, let's call it the next bridge dividend. They send out that letter. They send out the filing. The filing references the communications between FINRA. We've known in the past FINRA to do anything in this matter, it's taken them months. Really. You remember the first FAQ took like 100 days. They goofed that up, right? They didn't even get that right. They had to file
right out the next day.
They filed an amended FAQ, right? That's probably not accurate too. When we get to the end, they get this. They get a letter from NextBridge in April. From now that we have, because they disclosed it, and they respond to it in May. And remember, we had this discussion. I think this is an interesting discussion. So we're like 5 months in. And I looked, by the way, so I had the letter in front of me. So this is the letter dated May 19th here. And it's from Robert L.D. Colby, the Executive Vice President and Chief Legal Officer. So this is no schmuck. This is the guy, theoretically, who's in charge of the legal matters for Finra.
Right.
Not some guy off the boat who doesn't know Jack. Now, this guy may know Jack too, but I don't know. So when we got this, I looked at it and I called JR and I thought, you know, this is interesting because they did the FAQ, they did the amendment to the FAQ, they get the letter from NextBridge. They have a lot of time. They got like 5 months to figure it out. And then we get to the first page, the bottom paragraph, and I'm just going to read it because I find it interesting. So I'm not going to read the entire paragraph, just the relevant part. But the relevant part, I don't think it is taken out of context, just for everybody. But feel free to read it for yourself if you have any doubts. The trading halt was initiated in light of clearance and settlement concerns that arose due to the structure and timing of the NextBridge/MMTLP corporate action. Specifically, shareholders' interests in MMTLP, which had been publicly traded over the counter, were replaced with an interest in NextBridge NBH common stock. So this is the guy who's the chief legal officer who is saying specifically, I mean, it's not arguable that that's ambiguous, is saying specifically that the halt occurred after the transfer from MMTLP to NextBridge Hydrocarbons. Now, we all know that's false because that's not the case.
Right.
Because there was nothing. I mean, you could argue there's nothing today. But in terms of arguably, if all those instruments existed at the time, clearly there was no transfer. There was a U3 halt, no transfer. There was no activity or no delisting, I think, to the 13th of December. So again, chief legal officer of Finra, 150 days into this, with people bitching about it, is saying something that is objectively false. So I don't know. Yeah, I don't know if that's incompetence. That's just another attempt to shift people's attention, but it's objectively false. And it really pissed me off, by the way, that the guy would try that. And there's a subsequent letter because there's some additional conversation, but doesn't clean that up. So that's the state of the affair as of July 30th. That's what they maintain. Objectively false.
Well, I'm going to go back to what I said very early on that, you know, and I still feel confident about it. I just don't know when it's going to happen. That at some point we've now made enough noise as a community to push the Financial Services Committee, 15 members of that committee, to sign a letter to Gary Gensler demanding information. If that information that they get back is not adequate, this community, first off, the community is not giving up. I suspect that phone calls to these 15 people are going to be targeted over the next 2 to 3 weeks. So the pressure from the community is going to continue. And I said very early on, at some point, there's going to be a congressional hearing, and the words you're going to hear are, Congressman, under the advice of counsel, I would like to invoke my Fifth Amendment right against self-incrimination. It's coming. It's coming. These guys are dirty. They've been dirty. There's probably a few key players in FINRA that know this thing went south. They knew it was going south on the 5th. And if they knew it was going south on the 5th and they continue to let it trade for the 6th and the 7th, when it got the shit shorted out of it, that means they've committed just as much fraud as anybody else in this game. And they're going to go to jail. Somebody's going to go to jail if they don't fix this and fix this soon, because the pressure from the community is not going to stop. Think about where we were, and I'm talking to everybody now, not you, Richard, because this still comes back in my mind. This very seat that I'm sitting in right now, I sat in on the very first space that I was part of back on that weekend after it got halted. And think about how depressed everyone was and how, just mentally exhausted over this that weekend. And now, as a community, we have pushed the Financial Services Committee to send a letter to Gary Gensler demanding answers. If they think that this is going to stop, they are nuts. They are insane, because it's not going to stop. And now I suspect it's only going to get worse from the community.
Oh, I mean, it is. And I'm going to do it right now. So, that people have been asked to provide questions. So I believe these guys are so incompetent that even if I give them the question now, they'll still fuck it up, in my opinion. So,
are we allowed to curse on here? Are we allowed to curse on here?
Oh, I guess not. I guess not. Yeah. So my question would be what I just read. So this is me. I'm at a hearing. I'm in a deposition. I pull out the document. This is literally what I would do. I would read that passage to them. I'd say, do you believe that to be true and correct? They would say yes or no. If they said yes, then I'd ask them, well, when did MMTLP become Nexbridge hydrocarbons? And I'd elicit the timing, and they'd end up being in a bad place. If they say no, it's not correct, that's a different problem. But that's where I would start. I'd ask them if that's true, because it's fundamental to the reason they claim they initiated a U3 halt.
Right.
If the fundamental basis for the reason, at least in May, because we know the reason's going to change, right? Changes from March to May. It'll be different in July. It'll change according to the seasons. In the fall, it'll be different also. It'll probably be your hat in the fall is the reason for it.
If you go back to the initial corporate action, if memory serves me correct, the first corporate action came out on the 5th or the 6th. Am I incorrect in that?
Yeah.
So,
good.
and the S1 was effective November 18th. So it took them almost a month to come out with the first corporate action. And if you look back at the history and everything that's happened, you can't tell me that they weren't shitting bricks on the 19th of November after the S1 was finalized and trying to figure out how they were going to clean this up beforehand. Someone in Finra knew. Sam Drady's the one that got caught asking for a fraud investigation and pulling the blue sheets on December 5th, but someone knew what was going on, and they failed to do something about it.
Yeah,
I'm getting a call from a community member.
Okay. And along those lines, just, I'm in a arbitration with Fidelity. I repeat this too many times for my own liking. I'm filing a discovery motion. One day you're going to tell the true story, right? Right there, JR, little JR, mini JR. Yes.
I will, but not yet. Not yet.
So I'm seeking discovery. I'm filing a motion. So I have a list of people that I'm asking for depositions of. So we will see who I get to depose, but I have a new friend to depose, Mr. Colby, with this letter. Thank you, Mr. Colby. Besides the fact, by the way, I think, and I'm going to address the excuse for not agreeing to let the shorts trade. So remind me about that. Actually, let me address that before I go on. One thing in this letter, it says, in essence, we don't have the authority for letting Nexbridge trade. I think it was Nexbridge. Well, it could be an MMTLP. I don't know actually which entity they were referring to, but he didn't have authority. I think it was Nexbridge to let Nexbridge trade shorts close only, whatever. They didn't have that authority. They didn't say that there's something that specifically precludes them from that. Just said that they couldn't like unilaterally require that. Okay, right. We don't require unilateral, but I'm asking you. So let's make it a team effort. So I'm going to be the representative of the Nexbridge MMTL people, and Finra, you could be the other people. So let's shake hands on it, and we'll agree that it could do that. So now you don't have to make a unilateral decision. Obviously being a little facetious.
That's mutual assent.
Yeah, mutual assent. But we have the Sorrento case, right? Sorrento, I'll just refresh again. Sorrento bankruptcy case. Within the bankruptcy, there was naked shorting found by the court. And this is recent, past month or so. The parties got together, and the judge signed off on this, saying they could cover their naked shorts by either there would be some kind of offering, which there was, and if there weren't enough shares, then they could buy them from the company. The companies would sell them shares. So that was an agreed upon, basically, solution that we've all sought. In other words, cover only, 2 days trading. Now, again, I'm not saying that in our case we can get that, but it goes to what I'll give them the benefit of this doubt, that maybe the time they wrote their letter, they weren't aware of Sorrento Therapeutics, and they weren't aware that maybe you could work out some arrangement where the shorts could cover and it was permissible. So maybe they weren't aware of that, but they are now.
Right.
And they could certainly stipulate to it. They could work not unilaterally, but they could agree to it. They certainly could agree to participate in a case and accept the judge's order. They could do all that. Go for it.
So you've got one key distinction between Sorrento and NextBridge MMTLP, and that's that Sorrento and the Silax dividends, Silax, is still trading. So if I'm Finra, that's the argument I'm going to make. The ticker was deleted. It's no longer trading. NextBridge has a QSIP. But in turn, a judge could turn around and say, well, you need to figure it out. It's that simple. Figure it out and make it happen. The likelihood of that happening, though, is NextBridge needs to do something, and maybe they don't think they can. We've talked about whether or not they thought they had standing, and according to what John said several weeks ago, NextBridge doesn't believe they have standing from that particular end of it. But we know they've got.
Quickly interrupt for 1 second, then you continue. So standing means that you have the legal authority. By your position, you have the legal authority to pursue a lawsuit.
Right. So there has to be some type of harm against you, and not just any harm. I forget what the standard is, but NextBridge doesn't have standing on the back end. I'm sure they have standing on the front end for, look, we've got more shares than we're supposed to. We lack the ability to do things as a corporation because we don't know who our shareholders are. We don't know how many shares there are out there. So they have standing from the front end, but not the back end. But and it goes to Mark indicated this before. He gives it a 5% chance of trading again, and that's only assuming a judge puts a stay on the corporate action and some type of judicial resolution is worked out. But in order for a judicial resolution to be worked out, you got to be in court. No judge is just going to arbitrarily say, "Yeah, make a trade again," and that. So we've not seen any lawsuits other than the ones that were dismissed. Now, and I believe Rose's was dismissed on Friday as well too. You still have Hands of Steel. Yours is now going on appeal. I don't know what Rose is doing. I don't think she said what she's doing at this point. It's probably still pretty fresh. She's got plenty of time. Yeah. And what's the other one? Oh, Allen's is out there as well too. But again, you just don't know. I mean, we go back to what we talked about before. You were pretty confident yours was going to get through, defeat the motion to dismiss, and now here you are. And I'm sure all the other attorneys felt the same way. So, but you just don't know.
Well, actually, to be forthright, I was hoping to survive a motion.
Not what you said. You were no. My recollection was you knew it was going through.
Yeah, little JR. Thank you so much. What I probably said. I knew it was a righteous.
I'm kidding.
I know, but just to be honest, I was just to protect me from getting sued for malicious prosecution. Thanks, little JR. I thought I think we have a righteous claim. So whether we lose in court, that happens. Whatever. We obviously it's a difficult burden, but I still think we have righteous claims. So hopefully,
and I do too. It's that immunity hurdle. That was, and we kind of knew that. We kind of knew that going into it, that there was that hurdle, but that doesn't make the claim any less valid. That's.
Go
ahead.
What's funny is
as a lawyer, you're trained to make an argument. You're making an argument.
I was looking at that, because we've talked about like the courts are taking a much narrower position in terms of power and authority of FINRA and the SEC, and in some facet. Maybe the congressional oversight, in effect, is along those lines. But we don't know, in essence, where that's going to go. So we don't. I was going to flip back to one point that you were raising about the letters that were attached, and this kind of goes back to the FOIA issue. So everybody's filed FOIA responses. They come back and they say basically tough. We'll find some exception that applies. It's private, it's confidential, whatever. Here we have. I just find it interesting. And FINRA and whoever at the SEC will be asserting it, and they might be not disclosing a FINRA document, for example. Right. But here we have FINRA disclosing documents that they had no need to disclose. They didn't. And in fact, NextBridge was careful not to disclose them.
Exactly.
FINRA elected to. So I don't know, I don't know where it's going to apply. But, if somebody does something voluntarily like that, that may be a waiver of some type of privilege. So if you're like asserting confidentiality, but you make documents public, it's a tough argument to make something that is confidential. So when I saw that, that's one thing and I don't know where it's going to play out, but I know that.
That's a really good point. I mean, the chief legal counsel drafted those letters. They did not need to be made public. They were having negotiations on something, and negotiations fell through. I mean, technically, that's attorney work product.
Yeah, and think about it this way, and it's certainly, I agree, it didn't have to be produced, but if we kind of are, speculating, we think that FINRA thinks that somehow the language is to their advantage. And I read you a paragraph, right? I read you a paragraph of what they think is supportive of their cause, causing them to, from their chief legal officer, or at least, I don't know if he's still the chief legal officer, at least chief legal officer at the time. But I
think might not be for very long.
I know. I think really, that's poor work. I think if I did that, if I had filed, and I filed a series of pleadings. Kind of what the idea is, if you make an error in a pleading, the next time you file it, the idea is to correct that. And if you make an error in the next pleading, the idea is to correct that. At some point in time, it's not really acceptable because you're just so incompetent that it's, what can I do? But we've been through a series of these. And again, not a bump in the screen, but he still doesn't have it right, which means FINRA does not have it right, which comes down again. The only three choices: incompetence, corruption, or both.
Well, I'm going to go with corruption, and here's why. I mean, we had a huge week this week, right? We had the Wells notice, we had the subsequent S1. We had the congressional letter, then we had FINRA releasing their letters. So 2 points I want to make here. First point is, and I was thinking about this as you were talking, something you said, it popped into my head. We don't really know what caused them to release those letters. Was it the S1, or was it because they had a heads up on the letter that was going to Gensler? Because it could have been either one of those things. Maybe they thought about doing it when the S1 were iffy, and then they found out or got wind that the letter was going to Gensler and decided we got to drop this. But the one thing about this that I've been thinking about, and I've been thinking about it since day one. I know you have been. I know many other communities have been. But this entire week, there was still one issue they danced around, and that's the final share count. I mean, think about the letters that went out, the letters that came back, all the noise that was made over this. That's the one thing that makes this community go away. That's the one thing that shuts this down, is releasing the share count. And if they were right and the share count was 165.5 million, they would have done it by now. We are 7 months into this. The Financial Services Committee is throwing a hot potato at Gary Gensler. If the share count was right, they would have come out and said it. It's that simple.
Yeah, and by the way, to the Financial Services Committee, those members who are supporting the community, props to you. Even if I'm not of the same party, super props to you. Really, yes, really appreciated, and all the members who stood up, really appreciated, because it's a big step. Go
Yeah.
for it.
And Eli Crane as well, too. You know, his letter that went out, I mean, the pressure's mounting, you know, that these, and I hate to say it, but there's some level of appearance that they've now got a target on the SEC over this, and that's what we've always wanted. But, you know, it would have just been as simple as Finra saying a letter, hey, guys, yeah, we know there's some fraud that went on. We're doing an investigation, but the share count is 165.5 million. That's it. We know it. Or,
Yeah.
all right, it's 170 million. We got 10 million plus. We'll figure it out. We'll get it straightened out. But they haven't done that yet.
Yeah, and I was going to say there's 16. So I did reference 16.
Oh, 16.
Yeah,
Sorry.
15 plus Crane. So that's 16. That's what we include. And you know, again, props to you really for coming through, and also like people like Frank Nez. This is outside of members of the community who are like, you know, great. Everybody's put in a tremendous effort. But I want to add something. So let's not stop there, because these people are obviously allied to us now, and we're coming into an election year. So right. I think this could be a great election issue for all these people. But I want to make sure also they consider two things. One, I know they sent it to Gary Gensler, but the guy who I really want to hear from is Robert Cook, the guy from Finra. Yeah. So why not send a similar letter to Mr. Cook, who works under the SEC's supervision, to test out their story on this? They obviously were involved. The Congress people obviously know that FINRA had a role in this. So right. I would appreciate those same brave Congress people who stepped forward and sent the letter to Gensler, go forward and do the same thing to Mr. Cook. And right. maybe even Mr. Colby, the counsel who apparently knows what's going on. And separate and apart from that, and you know, we don't know how long this process is going to take. So you know, there's a schedule that we're aware of. August 11th, I think, is the first date. But you know, us knowing how things work, I wouldn't expect a response on that date. I would expect some delay, and maybe there's a back and forth, and it may be some time before Congress gets what they're asking for. Right. But if they don't, it is super important. And if there's ever a time to do it, use your subpoena power. So if this is a big issue to you, which you've come front and center, and you don't get satisfaction, then use your power. And your power is a subpoena power. Because you know, the agencies might be able to dick around with informal requests or letters, which they do, apparently. Yeah. But a subpoena power has a different impact. It might put somebody in jail for not cooperating. Right. They are very scarce. They, being Congress, are very scarce in using that power. But in this case, just kind of along what you were saying, this is not complicated. If there's not enough share, if there's too many shares, just say it. If the shares are correct, just say it. That's like a 1-minute discussion. That could have been handled December 12th. Really. If it was as simple as the share count's right, you guys are screwed. Sorry. They could have showed us the share count. Done. Right. 7 months in, not, you know, it's exactly kind of addressing everything but the main issue. All this nonsense about why we can't do this, why we can't do that. Let's start with the basic premise. If there's nothing here, then tell us there's nothing here. We don't need to waste our time anymore. Right. We just don't believe there's nothing here, and everything they've done to this point in time suggests they know that they're in trouble.
Yeah, and think about that. We've now rattled Congress's cage enough for them to send a formal letter to the SEC. Do you think if Robert Cook and FINRA had the share count and knew the share count was fine and haven't communicated that out, they would have communicated that out a long time ago. They would have made this go away a long time ago. They can't. It's either obscene, I think was Drew's word based on what he had heard from some congressional staffers, or it's, it's maybe 600 million plus, which is, I think, what Busy had said. It's somewhere in between there. We know that it's either god awful or it's just bad.
But yeah, just think about it.
They would have told Congress by now.
Think about it in this terms. Let's say they have a meeting, Mr. Cook, and I'm going to play Mr. Cook. So we could either disclose the facts today, or we could piss away 50 million in legal fees while we dick around with this, and in the end it's going to end up the same way. So which one do we choose? Are we going to piss away a bunch of money, or are we just going to deal with it and get it over with?
Well, I'm going to go back to what I said earlier. Somebody's going to be on the hot seat soon. It's coming. And when I say soon, I mean 6-8 months down the road. That's soon in terms of political terms. Yeah. It's not going to be tomorrow. It's not going to be next week. It's not going to be August 11th. But at some point, someone is going to be on that hot seat answering for this.
Yeah,
and we've said it all along. The evidence is going to bubble up at some point.
Yeah, I had a discussion today with Edward.
He owes me a soda.
Yeah, no, I always enjoy talking to Edward, and we were talking about it. And he asked me that question. We were talking about timing, and nothing has changed in my mind. I thought the facts are on our side. Eventually, we're going to be successful. I just don't know when. So now I'm having a different view. So once that congressional letter went out, now I believe that we're going to get a resolution sometime between today and the election, because I think it will be an election issue. I don't think it's going to be, all the way. I thought, I'll be up front. When this all started back in December.
Are we sharing this?
Yeah, my internal clock, 1 to 2 years to kind of get this worked out. So we're about 7-8 months in now. With the congressional involvement and it being a political issue, I think it's going to be resolved before the election, and hopefully a long time before the election. Right. And I think that's the fact that we're coming on to an election year, I think will be beneficial to us, because the ones who didn't stand up for it will have to also address these issues. And that's going to be tough for them to address it without being sympathetic to our position.
Yeah. So one comment first. Fee rhymes with AMC. Yeah. You're not the only one out there, and please, we're not trying to kind of be dismissive. We're just trying to give our opinion of where we think things are going. We would all want a resolution sooner rather than later. I will tell you that I don't know what the time period is, but I was, and I bet Edward this, so I'll share this. Edward is going to owe me a soda. I bet Edward that this was not going to be resolved in 2023, and I still stand by that. I don't think a resolution is going to be worked out before the end of the year. After that, I think it's up in the air. This could quickly pick up as we get closer to the election. It could certainly pick up as more pressure mounts, which I'm certain more pressure is going to mount. There's going to be a space call tomorrow morning with action items. Junk does one. I'm sure Ann will do one. Damn well Drew's going to be doing one. So there's going to be action items for the community. And the one thing that congressional letter did was it brought people together. It brought everybody together. Every space I was on at some point, and I jumped on a couple just to kind of listen and hear what the chatter was, but everybody was stoked. Everybody was excited. Everybody knew this week was a turning point, and it was a turning point because of all the things that happened. We learned that NextBridge was working behind the scenes, which you and I had a sneaking suspicion. We didn't know exactly what was going on, but based on what Drew had talked about back in May, we thought pretty confident that was being ping-ponged back and forth. We just didn't know the timing. The fact that there has been so much congressional pressure, enough for Eli Crane to send that letter, enough for the committee to send that letter. And one thing I want to point out is, yes, there was some noticeable signatures missing from the committee. There was also a noticeable party missing from the letter. I don't read into that. You know, these types of letters go out from one side of the aisle or the other side of the aisle all the time. The fact that there were no Democrats on there doesn't mean diddly squat to me. The fact that there were 15 Republicans on there, again, 15 committee members. Who cares whether they've got an R and a D or a D in front of them? You had 15 members of the Financial Services Committee send Gary Gensler a letter demanding answers on this issue. That's huge. It's huge. So the pressure is going to pick up. So at some point, again, we don't know when, someone's going to start asking the right questions. Someone's going to start demanding to know what the share count is. It's coming. Someone's going to be in the hot seat. It's coming.
And I'm not, and by the timing, when we throw out timing, we're not trying to be dismissive of the misery that people are going through,
right?
Because we understand that. But also kind of part of what we're doing here, at least our, kind of part of our pledge is we're not going to try to give you inaccurate information. So we're not going to say something we're not going to intentionally say something that's not accurate. What we're trying to do is give you accurate information so you can make your own decisions based on that. And I've said all along, before you make, and this would include whether you transfer shares or whatever you do, speak to somebody who's an expert that you trust before you make any material decision.
I'm getting text already about these comments, Richard. Listen, folks, listen. This is our opinion. And let me share this too. I will be happy, ecstatic to be wrong. Enough said. I'm providing my opinion. Richard and I talked about this. We decided, to kind of share what we thought based on everything that happened this week. I would be the first one to get on a space and say, hey, I was wrong. Throw the hard tomatoes at me, whatever. I mean, look how I walked with my tail between my legs when the Eagles lost the Super Bowl, folks. So, and Richard would be the same way. He'd be happy to be wrong too. Everybody just needs to take a deep breath. We had a big week, but we've got a lot of work to do.
Yeah, the way I would look at it slightly different. I would say we've set, at least I did. I set an outside date, not a early date. The date could be tomorrow, as far as I believe. I just believe now that it'll be decided before the election. That's all. It could be 9 months before the election. And again, we're sympathetic to people struggling. We're not trying to cause that. We're not causing that. We're just kind of basing it on our experience. And legal time is slow, and political time is slow.
Yeah, so, and I will tell you, I've been forthright with everyone that I've given my cell phone number out to kind of talk to about whether it was something that had to do entirely nothing with MMTLP or whether it had to do with MMTLP. This wasn't a great secret that I was keeping to myself. I mean, the bet with Edward was, but I'm at a point where I want my soda from Edward just for bragging rights at this point. But you know what? I'd be happy to buy him a soda. If I lost, and I would be happy to take shit from anybody if I'm wrong.
Yeah, I mean, we're giving an educated guess. We're not guaranteeing anything either way. We're just giving you a guess. We're at the point we are now, and we are estimating from this point. So we hope it's sooner, but we'll move on from that. One thing that is interesting is we believe that all this will help other tickers. So there's a bunch of other naked, shorted share securities that we think are out there. We've obviously been introduced to like GTII and Finra, AMC, GME, Mullen. I mean, there's a whole list. I mean, I'm a Tesla person. Tesla was shorted too, crazily, when it was in the tank. So we think if the Congress really opens its eyes to this issue, even if it starts with MMTLP, the next person that goes, basically the problem is we all claim there's naked shorting. They think we're full of crap because there's no real precedent for it. But now if it's accepted by Congress, investigated, and if there's some determination that it exists, the next party that goes there with their complaint will be treated differently because now it will be an accepted concept.
Well, so the other thing. No, I'm just going to say the other thing. If Finra gets wind that they're going to have to produce these numbers for MMTLP, And let's take a step back because we talk about GTII and Finger, and let's assume that Ham's right. Let's assume Ham is 100% right, and Finger is 150 million shares oversold, and GTII is 300 million shares oversold. If you're Finra and you know that you got to turn over information on MMTLP, you're going to be shitting your pants right now, because the communities for both Finger and GTII, they might not be as strong as MMTLP, but let me tell you something, they're going to get a hell of a lot stronger if something like that happens, because they're going to be able to look and see the results that the MMTLP community got by what they did, and they're going to do the exact same thing. There's no doubt in my mind.
And I was going to say, direct this to the the MMTLP community, is, there was a positive, obviously, ending to the week, but it shouldn't stop us from more aggressively pursuing our goals. Right. Because again, right. When you got somebody by the throat, you kind of like squeeze harder. We got them by the throat, and we got to squeeze harder. Really got to take advantage of the leverage. I was thinking about this. I've brought it up a few times, but it's interesting what happened. So I find this funny. So sometime when I started my channel, the owner of the Florida Panthers, and who has a hedge fund that shorts Virtu Capital, and I saw a headline today. They cited both Citadel and Virtu Capital, that their earnings in 2023 are substantially reduced compared to 2022, which to me I found as a positive news, not negative news. But anyway, I made a joke. The owner criticized my joke. I have no idea how he could criticize any of my jokes. But I just want you to understand what's happened since he's criticized my joke. His hockey team lost the Stanley Cup final. His company got crushed in 2023. He got a Wells notice. The owner. That's since laughing at the joke. So before anybody criticizes any of my jokes, think about Dougie. Think about Dougie.
I better not criticize your jokes. Hell, I
better watch
get a Wells notice.
Let's go back. We talked about that bankruptcy case and how that they got the share count, and that they had set up a system to get to naked shorts could cover. And we were saying, maybe that will play in somehow for the benefit of MMTLP. So the 27th was the cutoff date for those naked shorts who were confidential to cover. I went to the court file today, looking just in case.
Is this it, Richard?
Yeah, this is it.
Okay, hold on.
So the adversarial proceeding was dismissed without prejudice on the 28th, which suggests to me, well, one, something that we don't know could have arisen, or two, they could have covered.
Well, I think it would suggest to me, here's what I think. If it was dismissed without prejudice, that tells me that whatever broker had gotten that notice, they probably all just agreed to buy the shares from the company. Unless, we could be wrong, unless they decide to pick them up, or they pick them up Friday and are going to continue to pick them up Monday in the open market. The two things there's two big missing pieces here of the facts are, we don't know. We speculated that the asking price for the shares was $5.69.
Something like that.
I don't know what the share price. I don't know what the closing share price was. Let me look. What was the closing share price on Friday of Celiax?
It probably was after hours.
It was 538. It closed at.
Yeah, because
but it was up 13 cents on the day.
But I'm guessing the notice of dismissal was probably filed after hours on Friday.
It was up 13 cents on Friday. It didn't have any change in after hours, and there was only 700,000 shares in volume on Friday.
Well,
during
we're kind of what we said. It'd be
hours.
interesting to see, not financial advice, not legal advice, but it'd be interesting to see what Skylex does on Monday, how it's
Yeah,
reflected. Again, we don't know what happened, how
right,
they ended it. It was just the adversarial proceeding. So there's a bankruptcy that's ongoing, and then within the bankruptcy, there was litigation. So it's the litigation that got resolved. It
right.
wasn't the bankruptcy being dismissed. I've reached out. I called the attorneys. I sent emails to the attorneys actually today. So we'll see. I'll hopefully get a response, but it'll be interesting to see what, and I don't know if they can tell us or they're going to tell me to take a hike, to be honest. But it would be interesting to see what we can find out about how they resolved the positions with the naked short sellers, what they
Right.
did and what they can't say. I don't know if
Right.
there's a confidentiality agreement or something like that.
Brendan and Eli fun Ellie's fun adventures. We don't know if it's a good thing or a bad thing. We're not looking at it from an effect on the share price. We're looking at it from the legal
Yeah.
perspective. So
It just means that the lawsuit has been dismissed, so it's no longer pending.
The adversarial complaint inside of bankruptcy has been dismissed.
Correct.
We don't know why it was dismissed. So that brings up just one quick point. This is not financial advice. Neither one of us owns Sorrento or Silax. I would not. You guys need to figure that out. We're merely talking about the legal filings and following the case from an MMTLP perspective, because we think it opens a window for a potential solution should MMTLP or should NextBridge be in some type of litigation. It sets a precedence that any federal district court can use.
Yeah, and addressing, because that was a good question, because we talk legalese at times. So, we also mentioned prejudice, with prejudice, without prejudice. So with prejudice, when somebody says that, that means that the case is dismissed and you can't rebring it. Without prejudice means without prejudice just means that we're going to dismiss it. But as long as the statute of limitations hasn't run, we can bring it back again. And I was just going to briefly kind of go over that really quickly, kind of like in 30 seconds, the stages of a case. So, and that kind of fits with what the question is. So you have the initial investigation. Then if you find something, you have a complaint, which is basically the charges that are and claims you're making against the defendant or defendants. They can challenge the complaint. There's various ways they can challenge the complaint, depending on whether it's federal or state court. If they win those challenges, case is over, you can appeal. If they lose the challenges, case moves on, then you can do discovery, which is various ways of obtaining facts related to the underlying claims of the case. So you do that in written form, you could do that in depositions where you ask questions, etc. If the facts and law are not in dispute, then a party can file something called a motion for summary judgment, where they can end a case early and get a judgment without having to go to trial. Those are usually unsuccessful, but people try them, because if you succeed, it's wonderful. If the case is not settled after that, then you go to trial and you get a judgment. After the judgment, then you can appeal or not appeal, and kind of that's the scenario. So before they went to trial in Sorrento, and before I think they initiated discovery, they dismissed without prejudice. So theoretically, the party that filed the adversarial action, which is the company and the equity holders, they released those defendants without prejudice. So they're basically saying, depending on what happens, let's just assume for the sake of discussion, there was an agreement that everybody was going to make good. And in reliance on that, and let's say they bought shares or whatever they had to do. And in reliance on that, the plaintiff dismissed the case. But they may not have been sure that all they bought was 100%, or there might have been other claims that might have popped up. So maybe they were uncomfortable at this time dismissing it. But we don't know. We really don't.
Yeah, we don't know, but the you have to go back to the judge's order that anyone that participated in this kind of voluntary way to get out of their naked short position was released of all claims. So it makes you wonder if the defendants in the case didn't I mean, why would they not want to? I mean, it's a freebie. They're probably getting the shares cheap because they know if they go into the open market, people are watching this, people might be buying on this and holding, thinking this thing is going to pop. So it was a cheaper way for them to get out. I mean, I would be hard pressed to think that the defendants didn't sign up for it. And if all the defendants signed up for it, there's no reason for the claim to move forward. So
Yeah.
why wouldn't it be dismissed?
What's interesting, because we don't know who the naked short sellers are because they were hidden. Basically, that was kept confidential.
Well, let's take it a step further, though, because remember, they already had a judge declare that they had naked shorted the shares. So if you don't sign up for this offer, you've now got evidence submitted in a federal court with a judge agreeing with that evidence, saying you oversold the shares. You don't sign up for this offer, you don't lose that liability. You still have that open-ended liability. You've got, I mean, the evidence is there. There's nowhere to, hell, you're going to win on your complaint at the next. I mean, I'm being facetious, but you have the potential for your complaint to how do you deny that in an answer? How do you file a motion to dismiss when you've got a federal judge already saying the evidence exists?
And what's interesting is, so we don't know who the naked shorts, but we know who the brokers are. And it's quite a good list of brokers. So these brokers have been found by the court to have, engaged in naked shorting, lending on counterfeit shorts. Although there's no finding like that. The only finding is the naked shorting. But listen who the brokers are, because they're in the caption: Bank of America, Merrill Lynch, J.P. Morgan, Morgan Stanley, Pershing LLC, National Financial Services, State Street Bank and Trust Company, and UBS Securities. UBS obviously is
big prime brokers.
Yeah. So these are big guys who apparently may have done some stuff that may be not quite kosher, according to the bankruptcy judge.
It was just this one time, though, Richard. Just this one time.
Just this one time. Yeah, just this one time. Anyway, it's interesting. We're going to follow up, and to the extent we can get more specific information about what happened to the shorts, we'll provide it, and we'll work to provide it. And I thought, since I'm again in the discovery phase, I may try to depose one of these attorneys and see if I can get information out. If I get the chance, everybody's going to say no. Listen, I understand it's going to be a battle, but we'll see. We'll see how it goes. But we find that case interesting. Yes. Again, because of how the court was able to get a share count. And, we've tried, obviously, Mark tried with a petition. We've tried with our cases. It's a difficult task. In Dole Pineapple, they were able to get a share count, but it's really hard. And
yeah, but Dole was very unique. They got the share count because of the class action lawsuit and people submitting for claims.
Right.
I mean, this is not rocket science, and I heard someone say that, well, Finra can't provide the share count anymore because the data doesn't exist. That's about the dumbest thing I've ever heard. This is the most sophisticated financial regulatory body in the world. All they got to do is send an email to Fidelity and say, what do you got on your books? It's that simple. And I pull these types of reports all the time. Now it's not shares of a publicly traded company, but I can't tell you how many times I got to pull reports with data. You're not going to tell me that these organizations can't figure out what the final number is. And if they can't, then they shouldn't be regulating and doing what they're doing.
Not only that, let's be realistic. 7 months in, do they not know the real numbers by now?
Well, they know there is. They know it's out there.
And we know from the broker's perspective, because we have the FOIA reply. If this is my view, maybe I'm inaccurate, maybe it's not correct, but if FINRA asks Fidelity to produce their records as to MMTLP, and Fidelity does, I'm thinking that Fidelity might know that information at that point. If they give it, I think they might know the information. And that's true of every broker. And they all sold shares after that. So they all knew the information because they looked at it for themselves. So
it's mind-boggling to me that these organizations don't have some type of tripwire in their system where it says, hey, we've only got 1 million shares allocated to us. We're at 900,000. We've sold 900,000 so far. We've only got 100,000 left. If they don't have some kind of program that alerts someone sitting at a laptop that, we only got 100,000 shares of MMTLP left to sell, then not only are they incompetent, but they're not running their business correctly. They're running their business basically based on fraud. So again, it's just mind-boggling that anyone says that they don't have or can't produce the share count. That's about the dumbest thing I've ever heard.
Yeah, I mean that's nonsense. Even
Exactly.
if they didn't know after 7 months, even if they could, I mean, I don't know how you could even make an argument or a cogent argument that you didn't have the information. Even if they didn't, these are electronic records. This is like if I needed it, if it was an emergency, and the judge said, let's assume this is the case. Judge says, get me that information by the end of the day. They'll get the information to the judge by the end of the day.
Yeah.
I mean, I don't think it's any more difficult than that.
Yeah. Well, remember, the judge had to file a motion to compel because the brokers weren't answering. I guess they thought it was going to go away.
Right. Now, I'm going to just touch on this a little bit because I got a lot of questions people ask about the transfer. And obviously, the issue came up about the transfer of shares to AST. So I happen to be in a unique position because I'm suing Fidelity, so I cannot, or at least, my position is I don't want to risk transferring my shares to AST and then being shut out in my litigation against Fidelity. I don't know if that's in my own interest, but I think it's in the interest of the community to do it that way. But as to transferring to AST, especially if it's from a retirement account, especially if you don't know, really, you got to run it by somebody who knows. So if that's your accountant, if that's an accountant, if that's a expert ERISA guy, if that's a lawyer, somebody you trust. You have, it appears you have time, you have at least some time. And you probably can get an answer like that within a week, I'm sure. So you'd have enough time to proceed. But like any other decision, I really think you have to get an unbiased view from an outside expert before you make that decision. At least I would do that.
I think it's a personal decision. Everybody needs to make the decision, after some significant thought into it, especially those that have their shares in a retirement account. We don't know what the right answers are yet in terms of the tax consequences. And based on what I've seen, I don't think we're going to know. So it's a personal decision whether you transfer your shares or not. I will tell you, I've already had 2 or 3 different people ask me what I'm doing, and my response is the same. I'm not sharing with anyone what I'm doing because it's a personal decision. If you choose to transfer them, you choose to transfer them. If you don't, you don't. You have to read the S1, listen to the spaces that talk about the S1, and make the decision on your own.
Yeah, and I don't think it's necessarily an easy decision. That's why I always suggest to get somebody to run it by. And by the way, I haven't mentioned this before, but there is a logic to just running it by somebody. So if you go to your CPA and you spend an hour of time, you get an answer, but you get a lot more than that. What you do is you buy insurance. So if your expert gives you bad advice and you act on that advice, you just bought yourself insurance.
Right.
So that's the way I look at it. And that's why, besides the fact you shouldn't be making, unless you're an expert in the field and you feel comfortable making that decisions, and so be it. But, this is what I instruct people. So I'm just same instruction. If it's not something within your expertise, then seek counsel or seek advice.
Well, the other thing too is there was a little bit of confusion. I think it's been taken care of, but everyone was talking about 60 days from today. It's not 60 days from today. It's 60 days from the effective date of the S1. The S1 isn't effective yet. If you look, it's missing key dates, and there's a reason it's missing key dates. And everyone needs to remember, this is the same kind of S1 process that NextBridge through with Meta last July, when it was going back and forth. There could be one amendment, there could be 10 amendments. No one knows. No one. We're not on the inside. We're not going to know. The only way we're going to know is when the amended S1 gets filed and we see the changes. I think Tony was doing a really good job last year when the amended S1 came out. They were doing one of those side by sides, and you could see the number of word changes that were in the S1, and you could see where the changes were made. And so I'm certain someone's going to be doing that when the first amended S1 is filed. So again, plenty of time. Everybody, again, it's a personal decision. You kind of need to think it through. To Richard's point, you should probably talk to someone.
And like when Will Stewart's on, he's going to give you his pitch, what he did, and I've seen what he's done. He obviously, I think he's been on a Spaces, and he mentioned that he and I have had prior contact. So
right,
he told me what his intentions were. I think he went on a Spaces and said what he was going to do. He then sent me with statements. So he did transfer his shares to AST, and he obviously was a significant amount of shares. But that's him. That's his decision. That's based upon whatever he decided. Everybody should make their own decision, what's best in their best interests.
Right.
I don't know. I really don't know. And again, because I'm kind of in a stupid position where I kind of have to stay out of that, I'm not a good person to make that kind of recommendation.
Yeah.
And I don't know what I would do. I don't know what I would do. I mean, as I'm sitting here today, I really don't know what I would do if I were in the position. But my guess is I'd probably split it up. I'd probably hold some and send some. That would probably be my choice. But that would be just be me.
Yeah, I honestly don't know what I'm going to do at this point. My biggest thing has always been the tax consequences. So my decision is going to center around what the tax consequences are, and that's personal to me, So yeah, I just don't know. Just a couple of things I want to point out in the comments, though. Who is Ralph Norman? Is Ralph Norman a congressional person?
Yes.
He must have sent out did he send out an MMTLP, Ralph Norman's MMTLP tweet? So Jane Peck, thank you. Most of the people on this live stream love me more than they love Richard, so I appreciate that.
Except for JR, ironically.
So at any rate, yeah, I didn't know who Ralph Norman. I thought Ralph Norman was a congressman. I just didn't know, so I'll have to check that out. So,
and your tax reference, just so everybody knows, you're referring to the tax, specifically the potential tax implications that might come from moving retirement monies around.
Yeah. I mean, that's not secretive. My shares are in qualified plans, both a self-directed IRA and a Roth. So there's potential tax consequences. Now, there's no, I'm not going to go down that path. Everybody needs to kind of look at it from their own standpoint. But that's my overarching concern, are the tax consequences.
And that's an issue when somebody asks me. That's the first thing I look at, because that's the first thing that you should look at. Because as long as you make an informed decision, then so be it. Really, everybody can make a decision, whatever suits their interests, but be informed. Know what you're deciding. Because obviously, we've all learned that surprises can pop up that we didn't expect, and not all surprises are so wonderful as we've noted.
And if you didn't think surprises can pop up, then you missed this past week. So, ordinary angler, yes, Rosa can appeal her case.
Yes. She can file a notice of appeal, just like I had filed in the Ninth Circuit. It would just be in a different circuit. I think Mark's position, and I don't know I'm speaking for Mark, so I'm not going to speak for Mark. My interpretation of what Mark said was that would happen to be a difficult circuit for that position, because they favored immunity. They were really strongly in bed with the immunity for FINRA. And I was going to say, I'm sorry.
I was just going to say, I don't know. He would know way better than I would. So,
one thing I was looking at, I was kind of preparing, looking at Sorrento. I went back and I looked at any kind of documentation that dealt with these kind of arguments about FINRA, the SEC. And I went back, it's funny, to a 2008 law review article from like the Brooklyn Law School, where it talks about the three issues of about SROs, the non-delegation, the issue of the judges, and the issue of the constitutionality. In 2008, that's when these issues popped up. And it took like 15 years to where now the courts seem to be latching on, at least some courts are latching onto that as a viable theory, impacting both FINRA and the SEC.
Right. Well,
Right.
I know, right? I'm not surprised. I mean, look, these guys are smart. They have the highest paid attorneys in the world. They know how to maneuver the legal system and they know what to do. It's funny you say that because I read an article from, I want to say it was 2013, that talked about SRO's applicability to the Administrative Procedures Act. And as you know, that was where my focus was when all of this kind of went down. And the premise of the article was they are subject to the Administrative Procedures Act. And FINRA was part of that law review. And they talked about FINRA within that law review. Now they talked about a number of different agency or SROs, but that they're subject to the Administrative Procedures Act. Now, FINRA hasn't been tested under the Administrative Procedures Act, and Mark, I will tell you, Mark, and you know this, but just so the community knows, Mark and I, we had a very friendly disagreement on this. I think there's something there, but the problem you have with a lawsuit like that is if you lose, you've now set precedent. You've now set precedent across the country because they're going to be plugging that baby into every district court. Hey, district, down in southern Texas said we're not subject to the Administrative Procedures Act. So that's the risk you run with a lawsuit like that. But I think there's a strong argument to be made that they are subject to the, and when we talk about, let's take a step back. They are subject to the Administrative Procedures Act because they're promulgating rules and regulations, but they're under the guise of the SEC. So when you sue FINRA for their regulatory rule implementation, you're really suing the SEC because FINRA might recommend the regulation, but the SEC is the one that does all the requirements under the Administrative Procedures Act. But I think there's an argument to be made that they are subject to the Administrative Procedures Act. And that argument is getting stronger based on those two cases we talked about, because one of the open-ended questions in those cases is FINRA a state actor? And if they're a state actor, they are definitely going to fall under the Administrative Procedures Act.
Yeah, exactly what boy, you led me in that perfectly. I was just about to say that these cases that are going to the Supreme Court, in essence, are if they eviscerate the authority of the SEC, are going to make FINRA a state actor. And the significance of that is then FINRA has to comply with the Constitution.
Yeah.
And for example, the Fifth Amendment guarantees you due process rights, certain due process rights. So FINRA conducts a series, I'm just going to use this as an example. FINRA conducts a series of arbitrations that certainly do not comply with the rights I have in district court. And if in fact they're declared a state actor and they're administering arbitrations that we are forced into, then perhaps those arbitrations won't succeed as currently situated. Maybe they'll have to amend the rules to, for example, so I have to file a bunch of motions for discovery. So should I have to do that? No, I should not have to do that. It should be a matter of right and a matter of due process. Yeah. So I think kind of that's where we're headed. And that we talked about it. I don't know if we talked about it or I talked about it in the video. I think we talked about it. That case in Texas where the cops ran through this woman's. Yes. The case in Texas, the cops are chasing a bad guy. They run through a woman's house. They devastate the house. The cops asserted immunity. The court said that this is not an issue of immunity. You're a state actor. You can't take someone's property without just compensation under the Fifth Amendment. and therefore you have to pay the woman for the stuff. So they applied it, and I think, and I don't, again, we don't know how long this will be, but it certainly is the direction of the court, and it certainly appears they are going to limit the powers of these SROs, and it will certainly be for the benefit of retail. I mean, clearly.
Right. Well, we go back to what we've always talked about. These arbitrations are set up so that they're in the shroud of secrecy. I mean, you get in these things, the rules, the evidentiary rules, the procedural rules. It's the Wild West. Finra makes its own evidentiary rules. The arbitrators are hired by Finra. Now they have this phony, well, we want people from all over the United States of all areas of expertise to come on and be a Finra arbitrator. But in reality, let's I'll bet you the percentage of outsiders in terms of what Finra arbitrators are is probably, if you're lucky, 5%. They're all industry insiders. They know what goes on. These guys know the way the game works. They're not going to expose to the game. Otherwise, they're not going to get picked to be an arbitrator and won't be able to bill out their $8,000 a trial or $5,000 for reviewing motions. So they're not stupid. So yeah, if someone doesn't make the argument, and maybe it's going to be you, Richard, there's an argument to be made that if you're a state actor, these arbitrations are not following the normal rules of the Constitution.
And and again, that takes us back. So we started off with naked shorting, and then we're going all the way to changing the rules of how arbitration is conducted and how the procedure is conducted. So there is quite a vast amount of law that is going to change because of naked shorting, because all that is going on now. And again, it's going to work, even though we're focusing on MMTLP, and obviously we're of that ilk.
Right.
It's going to inure to the benefit of everybody in that situation. Just in case in the future, if you're involved in a silly arbitration, maybe you'll get a better result. Maybe it'll be easier process. Maybe it'll cost you less money. But all those things, I think, are headed in that direction, and it's all positive, I think. Yeah.
Wolverine, we don't know the answer to that question. Sorry, brother.
I'm going to quickly bring you up to speed. So the answer of fidelity in my arbitration is due this week. My motion for discovery will be filed this week. We then choose arbiters. We'll see when that happens. I'll obviously keep everybody abreast of, notwithstanding whatever I can't disclose. I'm going to, as I said, I'm going to be pretty much an open book about what I'm going to do. I don't feel any concern. Honestly, it's like an open book test. In my school history, every time I had an open book test, that was by far the biggest bear test I ever had. It was impossible to use the book. So I'm figuring, based upon how they conduct their business, I'm just going to be up front. Here it goes. Well, it's a layup. Let's see what you do with it. And, because you've had a lot of turnovers at this point in time, now the pressure is much greater. The likelihood of them making mistakes, I'm referring to the SEC and FINRA, increases now. Because just think about it. Whatever they've done to this point in time is with 7 months reflection, access to the documents, full legal teams, outside legal teams, and this is where they are.
Well, going back to what you said earlier about in order for you to be able to depose someone, it had to be an extraordinary event.
Yeah.
I think you got a pretty damn strong argument that, look, Mr. Arbitrator, the Financial Services Committee is looking into this. That's an extraordinary event in and of itself. The fact that the Financial Services Committee sent a letter to the SEC requesting information, that alone has made it an extraordinary event. This is not a normal run-of-the-mill stock market case that is. I mean, we know that. So
and just so that makes sense. So the rules of arbitration, there's limitations in discovery. You can do documents, exchange documents, but in terms of take depositions, they're not allowed unless there are extraordinary circumstances. So originally, and I still think it applies, since FINRA says U3 halt involved extraordinary circumstances, I think that's a fair argument. But on top of this, now we have congressional involvement on the same. I think this is really an extraordinary event
I just gave you I just gave you another sentence in your brief. That's all.
You did.
But I better damn well see a footnote at the bottom. Cited by.
I just said I'm going to cite you. I'm going to cite
see J.R. Ewing's comments on July 30 at 7:54 p.m.
No, I'm not going to say that. I'm going to say see tiny little mini J.R.'s comments on page 42. Yeah. So, that is interesting because it does, I think, provide us extra access. And we'll find out where it goes. And I encourage, if anybody else is in a position, because I was talking to somebody about this too. As far as I know, this is the only arbitration that is going on at the present. So I will certainly keep everybody apprised of what's going on. So if they so choose to elect to do it, they can have at least some insight. And JR will be my bodyguard at the arbitration, just so it's clear.
You're a legal trailblazer, buddy.
Just bring a rake with you, please.
I'll ride in on my motorcycle. How's that?
All right. I'm just going to leave you with one thing. Obviously, we're going to pay attention to what goes on during the week. And again, Tuesday night, we'll have William Stewart. Yep. We're going to talk about this. We're also going to talk about real estate because that's his expertise. So we all know, that there's an issue about real estate in the United States, commercial real estate. So let's take a look at that. It might be interesting for people out there who have an interest in real estate besides MMTLP. We also, and we'll see how it goes, I have to be careful how I say this. As certain trials progress in 2024, certain trials that might be interesting, we will address them in a procedural way. So we're not going to take a position on merits, but as what we're trying to do on important trials that we can kind of figure out what's going on, we will tell you what's going on. We're not going to tell you how it's going to end or anything like that, but we're going to try to keep you apprised of what's going on so it'll make sense for everybody, and they'll be able to kind of make decisions better or more meaningful for you.
Yeah. Frank J., not tonight, brother. Not tonight.
Any other questions that you see that you want to address?
No, I didn't see anything. I tried to address the big ones as they were coming in. Who MMTLP? How illegal was it that they got our dividend that wasn't supposed to trade at? I mean, we've talked ad nauseum about how they got it to trade.
I was going to address that. I know people are asking questions, so this is my speculation. Maybe it's educated speculation, but my speculation is one reason about the last week's events would be maybe it might help ascertain what the share count is.
Yeah.
Perhaps that might be an occurrence. Because I saw one question that seemed to be around that issue. What was the purpose of what was being done? I don't know. We don't know, but we are guesstimating that may be one of the reasons that it was done. Anything else you want to address?
I'm just looking through. Yeah, copy and paste. The short answer is we don't know why the Democrats didn't sign it. I can't read anything into it. I mean, there's an argument to be made there that if the SEC was a Republican and the Democrats were in charge, Republicans wouldn't have signed it. I mean, I put no stock into who signed it and who didn't.
My speculation on that is, and it doesn't really help us, but Gensler was appointed by the current administration. Right. So the current administration, even if they're not fond of Gensler, they have to back him. And as a result, their position would be, supporting Gensler. Right. Maybe that'll change. It should change. Obviously, it should change. But I think that's kind of our speculation as to why it was like that.
Right.
Yeah.
No, that's all I saw.
Okay.
Yes, this is what I look like. Morning. I'm not even going to read that guy's name.
Next during our next live stream, maybe Tuesday night, the JR can start us off with a little guitar solo to get us going. I know he plays guitar, and we'll see it. We'll put him to the test.
Maybe one Sunday we will. Well, hey, and I'll say this live. I'm not going to be around next Sunday, just so you know. I'm at the beach and just taking some time off of all of it, unless something big happens. Okay. Then I'll check back in. So
okay. Other than again, join us Tuesday for some more. Maybe we'll have more information. We'll also get Will Stewart's view on this, more information. He might have also a better understanding of the property itself, the Permian Basin property, which I know nothing about, and I'm not an oil person. I don't think JR, although ironically, JR is not an oil person. How do you like that? But hopefully we'll get some more information. And again, we're going to follow all this stuff. So if anything breaks in the meantime, we'll address it. And we will. Yeah. And when this comes on afterwards, I do look at the comments afterwards, because can I sing badly? I can sing badly if you want.
No, man.
If anybody, because when we watch these, if we're going to look at the video afterwards, we don't see these comments, but we see new comments. So if anybody has any additional comments after they look at this, put it on, and I'll try to address them.
Actually, let's do this. Anybody that's watching this, if you can figure out how to make the comments from stream appear on YouTube, let Richard know. He doesn't know how to do it.
Yeah, another thing I don't know to do, unfortunately. And to all of you who are complaining about on my last video, my microphone, I bought a new microphone, so it'll be here Tuesday. How do you like that?
I got 2 texts from people telling me to tell you to turn your microphone up. I'm like, I can hear him fine.
Yeah, I don't know, but I took them to heart, and I bought a new microphone. I'll have it Tuesday, and I tried to speak very close to my microphone tonight. Anybody, seriously, anybody who has any questions further, if they see it when the thing gets posted, when the video goes up, if you have questions, just put them in there, and we'll try to address them.
Yeah.
And again,
I read through them too. It just takes me a couple of days, and then I go out.
Yeah. And again, if anything pops up in the meantime, we will be here. We look forward. We think there's a lot of pressure on all the shorts now, and maybe a lot of them will start to run. We hope, I hope for AMC and all, I know BBIG got at an unusual event on Friday. They got delisted.
Yeah, I haven't been following that, and I'm losing capacity in my brain with all these tickers we're talking about. Maybe we should take a closer look at that, because I know Mark is now involved. He's now representing a group of shareholders, but I don't even know what's going on. I have no idea.
Apparently, and I don't either. It's not something I'm invested in, but I know it went. People were taken aback, because all of a sudden it would be like, we're trading on Thursday, and on Friday gets delisted, and nobody knew until Friday. So It was odd. It was odd. And listen, there's a lot of shenanigans going on in the back. We know there's shenanigans going on in the background. Who knows? But we're going to address it to the extent it applies to the tickers that we're following. We will, just like we're doing with Sorrento, we're going to try to hook it in to provide possible avenues for solution. We don't know if it's going to work, but we'll provide it. Whatever.
Right.
Anyway, to all you out there, thanks for joining us. Have a great night.
Yeah. Good questions, good comments. Thanks, everybody.
Yeah, we appreciate you following us and taking your time to spend the time with us. And again, if you have further questions, comment, and we'll try to answer them. Everybody be well, take care, and we'll see you Tuesday night.
Yep, we'll see you. Have a good night, everybody.
Take care.